All right, please. Hey. All persons having anything to do before the hour. The justices of the appeals court now sitting at Boston within and for the Commonwealth. God near, give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Whoops. Welcome to the appeals court. I am Justice Rubin. To my right, Justice Desmond. To my left, Justice Allen. We will be hearing in person today 4 cases. The rules are, as they always are here, which is 15 minutes per side with no rebuttal. I'm just looking to see, there's no impoundment order. All right, so our first case, number 24954, which is Commonwealth versus Ramirez, and we will be hearing from Attorney Opperman.
Good morning, and may it please the court. Aaron Opperman on behalf of Ms. Ramirez. I'm here today asking the court to reverse Ms. Ramirez's...
Hold on a sec. I don't know why our clock has not started moving. Oh, go ahead. I'm sorry. You can start again.
I'm here. Good morning, and may it please the court. Aaron Opperman on behalf of Ms. Ramirez. I'm here asking the court to vacate Ms. Ramirez's convictions and claim 3 errors occurring in the trial court. I'll start with what I think is the easiest way for this court to dispose of this issue in favor of the defendant, and that's the Doyle error that occurred during trial. There's no contention from the Commonwealth that there was no error. The issue only is whether the error was harmless beyond a reasonable doubt. As this court knows, circumstances upon which the admission of a defendant's prior invocation of silence to the police will not occasion a reversal are few and discrete, and reversal is the norm rather than the exception.
Do you have a case with curative instructions like this or limiting instructions like this?
Limiting instructions?
Well, curative instructions, really.
I wouldn't have called what occurred a curative instruction. The evidence, at least as the second testimony regarding the defendant's invocation, was stricken. I don't believe what stricken means or meant was explained to the jury.
Doesn't the judge tell them a couple of whole sentences about that they're not supposed to consider it?
I didn't think so, but if I'm wrong, I certainly trust this panel's reading of the transcript.
I may be mistaken.
I didn't review that specific issue in preparing for the argument, but I did not think so. I believe that the second statement that Detective Arana testified to was stricken. However, the first statement wasn't stricken.
So the first, I know when you were looking at the factors, we say that the government introduced the first statement, but I'm not sure that the first statement was a direct response to the question. What do you say to that?
Well, respectfully, I do disagree. And I have...
What was the question again?
I actually have the transcript here, so I will read it verbatim. The question was, Commonwealth, okay, and was she given Miranda warnings? Yes. And what are Miranda warnings? Her rights. Okay, was she told? And did she say if she wanted to speak to the police?
So that's a yes or a no question. Did she say that she wanted to speak to the police? Yes or no? That's not did she, that doesn't ask you to invoke whether or not she invoked her right. That question does not call for the response that they got. What was the response? So
I do believe, I do agree that in a literal reading of the question did not ask, did she invoke her Miranda warnings? Did she indicate that?
That's the issue. That's what we're talking about.
Correct. But I don't agree that that Detective Arana took it the way that Your Honor reads it.
He may not have, but that's not the Commonwealth's fault.
It is the Commonwealth's fault, and it is because the Commonwealth knows the answer to the question. So even assuming which I don't think is an unreasonable reading of the question. I think in a literal sense that is, the question is, did she say if she wanted to speak with the police? So yes, she did say that, and she said she didn't want to speak with the police. Why even ask the question if the answer is yes, she indicated whether she wanted to speak to the police, and the answer was she did not? So
Well, I
if
mean,
that's
I have
the
to say,
answer,
as I look at this, it seems as if the judge understood the first answer to be she did not say, right? Because he overrules the objection, but as soon as she volunteers non-responsively after she did not want to speak to the police, the judge jumps in. I'm sorry, the objection is sustained. There was no objection right there, so the objection that he's sustaining must be the previous objection, and he then strikes both, right? I think.
so I think I disagree that the answer from Detective Arana was answering the question as Justice Desmond is interpreting it. I don't disagree with that interpretation, but I don't agree that her answer was simply she did not answer the question about whether she wanted to speak with the police, because that's also not true. She did answer that question. She did answer the question of whether she wanted to speak with the police, and her answer was no. So because Detective Arana says, did she say if she wanted to speak with the police? She did not. That's not the accurate answer to whether she answered the question, did she want to speak with the police? Because the answer to that question was yes, she answered the question. Detective Arana...
No, I agree that once you hear the second answer, it clarifies what was meant by the first answer.
So, I think a totality of the kind of 2 to 3 questions here results in a conclusion that it was the Commonwealth who elicited this invocation. There was absolutely no reason for the Commonwealth to ask Detective Arana about whether she was given her Miranda warnings, whether she indicated whether she wanted to speak with the police, or anything in the realm of that topic. The answer was she indicated whether she wanted to speak with the police, and she said she didn't. She invoked her Miranda warnings in a formal manner, and the topic was irrelevant at trial.
That may be true. Had she not said, and she didn't, would there have been anything impermissible about the question or the answer?
I don't, if the Commonwealth says, did she indicate whether she wanted to speak with the police? Yes, she answered that question, and then they don't introduce a statement. That in and of itself implies that she indicated she did not want to speak to the police. And yes, in those circumstances would have been improper and would have meant that the Commonwealth introduced the issue at trial. Irrespective of this particular factor, there are 4 other factors that also favor the defendant's argument that the conviction should be reversed for this reason. And I think, as I certainly argued in my brief, that all of those factors favor the defendant in this case as well. The factors being not only who introduced the invocation at trial, which the defendant's position is that it was the prosecutor. Even if it wasn't the prosecutor,
It was a government witness.
It was the police officer. So still the Commonwealth, as far as this analysis goes. The relationship between the evidence and the premise of the defense, the evidence went directly to Ms. Ramirez's credibility. The defense was that the complaining witness was lying. There was almost no corroborating evidence save for the statement supposedly overheard at the police station, which is subject to another issue in the appeal. The weight of the guilt, again, no corroborating evidence, no independent forensic evidence, no independent witnesses. There were numerous inconsistencies that defense counsel capitalized strongly on during closing. The complaining witness's father was home at the time, so an opportunity for potential corroboration was not present or not, did not come to fruition. Assuming that the first answer of Detective Arana is referring to the defendant's admission, that was not stricken. It was only Detective Arana's second statement that was stricken. So I think the weight of the guilt also favors the defendant. The frequency of the evidence, it was two separate answers that touched on the defendant's understanding that the police wanted to talk to her, indication that she was going to answer the question about whether she would speak to them, and the answer that she did not want to speak to them. And whether there was a curative instruction. That the court did strike the second statement by Detective Arana, but there was no curative instruction regarding, one, what stricken evidence specifically means, or two, a strong curative statement regarding they should absolutely not consider that, et cetera,
Can I
et cetera.
ask you, do you have a case in which the offending testimony was stricken, but the court nonetheless said, no, there's a constitutional error and we reverse unless harmless beyond a reasonable doubt?
So I don't, I believe that in Mahdi it was stricken. There was a robust analysis of the harmless beyond a reasonable doubt issue in that case. And in that case, I think the evidence against the defendant was even stronger. And the issue still came out in favor of the defendant. The court saying, going so far as to say the weight of the evidence alone is insufficient to nullify an admission of a prior invocation. I forget, and I'm, Your Honor might know, seeing as how you were on that panel, I forget if the evidence was stricken in Lima. But Lima is obviously one of the closest on-point cases as far as the Mahdi factors.
Is Monty in your brief?
Yes. So I do think that this is, again, the easiest way to resolve the appeal generally in this case. I would argue that all of the factors support the balance tipping in favor of the defendant here. If the court has no more questions on this particular issue, I did want to skip the voir dire issue and discuss briefly the issue of the defendant's statement and the defendant's claim that it was erroneous not to include the statement entirely at trial, and would certainly ask the court to opine on that, even if they did reverse this case on the Doyle error, because this case would possibly be retried. It was error for the court not to exclude the statement rather than simply provide an instruction. The basis for a remedy for lost or destroyed evidence is to bolster or urge the Commonwealth to effectuate its duty to disclose evidence, particularly exculpatory evidence, and to support the defendant's right to a fair trial. By affording a remedy in this case, it's clear that the court found that the defendant met the first step of the test with regard to obtaining a remedy for lost or destroyed evidence, that there was a reasonable possibility based on concrete evidence that access to the material would have produced evidence favorable to his cause, or that the Commonwealth engaged in bad faith or reckless acts. So I think the issue is...
What do you have to show that it would have been exculpatory?
So the police report of Detective Bruzzese indicated that initially Detective Arana told her the defendant made this statement about the blue pills and that she denied to whoever was listening to her on the phone, I didn't do anything to him. So the denial suggests that the entire conversation as a whole would have been more of a denial than an admission. The statement, you know how I get when I take those blue pills, I don't remember, it sounds not good. It can, I think, very readily be interpreted as an admission or within that realm of a statement, but it does directly contradict the other part of the statement that Detective Arana claimed to forget, but was impeached with, that the defendant also denied the crime. So there's something in there that, in the conversation that was lost, that explained or reconciled those two things. She could have been saying any number of things. She could have been asked, why might he said you do that? I don't know. Maybe we got into a fight. I don't remember. There are a lot of different possibilities as far as what is the statement about the blue pills and affecting her memory refer to, but the way it was presented, it read that she was forgetting whether or not she committed the crime. I think that is probably how the jury took it. The jury in this case clearly struggled with rendering a verdict, taking 3 days to deliberate, returning twice to say they were deadlocked, only convicting the client after a Tui Rodriguez charge, and the lack of context, the extremely clear and multi-layered culpability of the Commonwealth and the police in this case in failing to get the defendant this evidence. Detective Bruzzese wrote this supplemental report 2 days after the statement was made. The report itself wasn't turned over to the defendant until 5.5 months after the statement was made. So not only did Detective Arana not indicate or convey to the defendant through the prosecutor this statement was recorded, which she testified she knew, they also didn't inform the defendant the statement even existed until it was just about too late.
Okay, your time has expired, so unless I see
If there are no
other
further
questions,
questions, I rest
we
on
have,
my brief.
yes, and we
Thank
have your
you.
brief for the other argument.
Thank you.
So thank you very much. We will hear next from Attorney Lynn.
Good morning, Your Honors. May it please the Court, Paul Lynn for the Commonwealth. There are many cases, many of which I cite in my brief, which have held that a passing and stricken reference to the defendant's silence can be a harmless error. I cite Braley, Isabel, Peixoto, and Thompson.
Yes, I've looked at Mahdi as well now, and it seems clear that a curative instruction or strike, I don't know about striking exactly, doesn't necessarily render the error harmless beyond a reasonable doubt, but that it's a factor.
Correct, correct. But here, the prosecutor never mentions it again, doesn't mention.
I've never understood this fleeting mention. Okay, did the jury not hear it? I mean, it's like the Commonwealth comes in sometimes and says, like, it's his confession. It was never mentioned again. Yes. And it's like, yeah, well, I think the jury heard it because he was busy confessing, you know? So I'm not sure about this. I mean, I know cases say it. Let me ask you this. Why did the prosecutor ask him if if the defendant had been Mirandized?
I can't answer that question.
Is that a proper question? Is that ever a proper question?
It was an ill-advised question. I will concede that.
Well, what's it relevant to? How does it adduce relevant evidence? When is it ever relevant whether someone got a Miranda warning? And then the prosecutor asks, well, what is that, Miranda? And doesn't get the full, you know, could have gotten an answer like that the defendant had a right to remain silent and so forth. Instead, just got, you know, it's the defendant's rights. I mean, I don't know who talks to line prosecutors about it, but when I look at Mahdi, there was another, it also began with this whole question about, and then was the person Mirandized? And it's like, prosecutors shouldn't be asking that. It seems. I mean, if it's specifically relevant for some reason.
It's a fair point, Your Honor. I think that this was an ill-advised question. But the judge, as soon as he realizes what's going on, breaks in, strikes the statement by Detective Arana. And then again, after the sidebar, says, you can, I'm striking that last statement. The last statement by the officer, or the detective, is stricken. And he, again, in the closing argument says, anything I struck, you can't consider.
Do you agree that this case was he said, she said case?
Well, it was whether what he said was true, because there was no statement by the defendant except that she didn't do it, which came in on cross-examination.
On cross.
Beyond his testimony, there was no other evidence?
No, just the testimony of the victim and his mother, that the victim reported this.
So with that as the backdrop, do you think that this error with respect to Miranda is more glaring?
Is what, Your Honor?
More glaring?
Oh, no, because again, it's a moment, as soon as the judge realizes what's happening, he strikes it, it's never mentioned again, it's never part of the prosecution or the defense for that matter. In those circumstances, it's harmless beyond reasonable doubt. But yes, it's not an overwhelming case. The Commonwealth concedes that too. Again, I will skip the challenge of the jury issue unless the court has any questions. Turning to the recording of the defendant's statement, both of the police witnesses testified that they didn't even realize that this was an issue. It was clearly a matter of negligence, not recklessness or bad faith. The defendant was nonetheless able to elicit exculpatory evidence from Detective.
So this isn't a Brady violation claim. But what do you mean they didn't realize this was an issue? I'm trying to figure that out. They report something that was said on a recorded call. Why didn't someone, the prosecutor at least, say, hey, I'm going to need that recording to turn it over to the other side? This seems really, I don't like lost and destroyed evidence much. I don't, it seems like it shouldn't happen, particularly the police. All they do is collect evidence, so.
I think it's an issue in this case that by the time the prosecutor and the defense counsel realized there was an issue,
Well, how would the defense counsel have realized it? How would the defense counsel have realized it?
When he found out that the phone statement was recorded.
Found out from the prosecutor?
Well, he found out.
Oh, no, from a visit to the
Yes,
station.
from the visit to the station.
Okay.
Yeah.
Wouldn't you expect the police to secure that recording, given their view was that she arguably made an admission in the call?
I'm sorry, I'm having trouble hearing.
Wouldn't you expect the police to secure the recording, given they actually overheard her, according to the record, make an admission?
It's
during the
something
call?
they should have done, but they both were cross-examined both at trial and at the pretrial hearing, and their response was, it just didn't occur to me. But again, the defendant was able to elicit from Detective Iran after she at first didn't remember it. She was shown the report. She said, yeah, he did say that, which is, or she did say that, which is that I didn't abuse the victim. The statement was not central to the Commonwealth's case. It's not even mentioned in the prosecutor's closing argument. The prosecutor's closing argument is completely dedicated to whether the victim is credible. And the defendant attacks it in his closing argument. And there's also a jury instruction that the jury can infer that if the police had, the reason the police didn't retrieve the statement and allowed it to be destroyed is because they knew it would be harmful to the Commonwealth's case. And in those circumstances, this was clearly within the judge's discretion to admit the statement. If there are no further questions, the Commonwealth will otherwise rest on its brief.
I see none. Thank you very much. Thank you
Your
both.
Honors.
Very helpful. The case is submitted. The next matter we will hear, if I'm right, is Commonwealth versus Cordova. I think that's right. This is number 25492. And I believe we'll hear first from Attorney O'Meara Costello.
Good morning. May it please the court. My name is Ruth O'Meara Costello. It's my pleasure to represent Mr. Miguel Cordova in this appeal. I want to focus today on the two evidentiary issues at trial, limitations on admission of evidence of bias regarding the complaining witness's mother, and authentication of the Facebook messages between the mother and a Facebook account she claimed belonged to Mr. Cordova. On the first issue, the defense's entire theory of the case was that the mother had manipulated her daughter into making these specific allegations against Mr. Cordova as revenge for his infidelity over an extended period of time. So this was evidence that went to the bias of the mother as a witness. She did testify at trial, including to inculpatory statements by Mr. Cordova, to which she was the only witness. But it also goes to potential bias and motivation of the complaining witness herself. There was evidence at trial about her, the way in which her life at that point put her extremely much under her mother's thumb, and of how, following these allegations, her relationship with her family, and specifically with her mother, improved. So it was extremely an important question, the credibility of these witnesses. And what the court excluded was the evidence following the allegation. And so evidence that the mother, prior to her daughter's allegations against Mr. Cordova, had essentially engaged in domestic violence against Mr. Cordova, that she'd physically attacked him, that there had been multiple kind of incidents in which her behavior towards him and towards the other woman that he was seeing was very extreme, did come in. But the fact that she had continued to engage in that behavior after her daughter's allegations did not.
So what does that show?
So I think that what it goes to, you know, the Commonwealth made a nice point in its brief that somebody's feelings of betrayal about infidelity don't necessarily dissipate with time. I think that's true. But in some circumstances, they do. In some circumstances, I think that a jury could think either time or this intervening very significant event that's disrupted the family could dissipate those feelings. I think it's significant that during the entire time that the mother is in many ways moving this case forward. She's bringing her daughter to the doctor, you know, close to a week after the events are disclosed. She's going to the police again close to a week after the events are disclosed. At the time of trial, she's identifying new witnesses on the eve of trial. She's producing text messages on the eve of trial. Her motivation for that behavior is in question and is not evidence of how she behaved towards Mr. Cordova and towards the other woman is relevant to that.
Mr. Cordova is one thing, but toward the other woman, 6 months after the fact at a happenstance meeting at a Target, I think it was, I mean, at some point, like we would do for the defense, we have to ask the trial court to weigh the probative value of that evidence versus the prejudicial value of that evidence. And that goes both ways, not just for the defense, but also for the government, right?
So I would say a couple of things. One is, I think that it's actually potentially more significant to jurors that it was behavior that was aimed at Ms. Diaz as opposed to at Mr. Cordova himself. I think that if it had been behavior aimed at Mr. Cordova himself, you know, her daughter has accused him of something really awful. And so behavior towards him could be motivated by that. Behavior towards his girlfriend is definitely motivated by anger about infidelity, and it shows something about where her mind still is after these allegations and as she's moving the case forward, as she's preparing to testify.
So what does that have to do with whether or not he committed these acts?
So again, the entire theory of the defense was that he did not commit these acts and that he was being accused of them as revenge for his infidelity, that the mother was manipulating the daughter into making these allegations, and that not only her own testimony but her daughter's testimony was affected. this is a case where the testimony was at the heart of the case. It's not a case where there was, significant extraneous evidence. In fact, if anything, where you would expect there to be evidence based on witness testimony, it didn't turn out to exist. I also will say we're not talking about significantly cumulative evidence here. I think that the defense proffered evidence of essentially 3 incidents, one in January of 2018 where the mother physically attacked Mr. Cordova and punched him, one in September of 2020 where she went to Ms. Diaz's home and made a scene in the street, and then one following the allegations. This isn't something that would have created some, it wasn't especially cumulative because we're really only talking about a few incidents, and it wouldn't have taken significant time to introduce at trial or been a distraction. I also want to note specifically that the mother was cross-examined about these couple of incidents that occurred prior to the allegation. The judge did not let in the evidence of the incident at Target after the allegation. And then on redirect, she testified at some length about how after the September 2020 incident, but before the November 21st, 2020 disclosure, her relationship with Mr. Cordova and with Ms. Diaz had improved. She said that she had a friendly text exchange with Ms. Diaz. She said that she felt like the two of them were finally sharing information. She felt like the two of them were at peace, and she said that she and Mr. Cordova were, quote, pretty good in between those dates. And so she's permitted to basically say to the jury, this was not something that was continuing to motivate me in November of 2020. This was not something that was continuing to motivate me, or that is continuing to motivate me now as I'm testifying to you. And that went unrebutted because the defense was not allowed to put, that's something that it was possible for her to imply because the defense was not permitted to put in evidence of this May 2021 incident at Target.
Can I ask you about because time runs short, the authentication instruction or the absence of an instruction? Let's say I agree with you that the issue is raised for Oppenheim purposes. And now the question is, must the judge instruct? Now, you didn't ask for this instruction. So are you saying, although the Commonwealth did and was told it would be included, but I don't really know understand what happened after that, I suppose just wasn't presented by the Commonwealth, and so the judge didn't include it. Are you saying that in every case where the issue is raised, the defendant is entitled to an authentication instruction like this?
I believe that, yes. I think the answer to that is yes. If you look at the language of the cases, the trial judge's role is to determine whether there's evidence that's sufficient, if believed by a jury, to authenticate the messages. But the question of whether the evidence is credible, whether the jury does believe the evidence or not, is a jury question.
Now let me ask you this. That standard is the standard routinely used for authentication. Here's a diary of the defendant or victim, whatever. Here's a pen that was found on the street after the shooting, whatever it is. In every case, the judge has to determine, is there sufficient evidence in the record from which a jury could find by preponderance of the evidence that this is what it's claimed to be? Do courts routinely give an instruction about, you have to determine whether all the evidence by preponderance of the evidence is what it's claimed to be? Is that a normal instruction or not?
I don't know that I know the answer to that question, Your Honor.
Well, I don't know why. Are you saying this is different, or this is just, right, because that is the normal test?
That is the normal test. I guess I would have to say that I think that it is different because the decisions of both this court and the SJC are clear that it's a jury question whether to consider the evidence.
It's always a jury question.
And yet, in this case, I think that there is law about that an instruction should be given. I think that it's more akin to something, and I think that it's more akin to the way that the courts have handled humane practice. I do think that courts, looking at the other published decisions, it does seem like many of them note that the court did give such an instruction, and so it seems to me that at least as to this issue, the courts are routinely giving them.
Do we know if any of those were sua sponte or who? I mean, it's not in the model jury instructions, presumably. If there are even model jury instructions. Not that I'm a believer that those state the law, but
I don't believe that if the cases recite how it came about that the instruction was given, I don't recall it. My best recollection is that they don't, that it is a factor that's mentioned in considering authentication on appeal. I also think that those are all cases that are that are not concerned with the jury instruction, but they're concerned primarily with the question of authentication and whether there was sufficient evidence of it.
You also
so
say that there's a substantial risk of a miscarriage of justice here. Now, of course, the Commonwealth didn't put in evidence like any 10-year-old can doctor what looks like a Facebook record, right? They didn't put in anything like that. So how do we determine if there's a substantial risk of a miscarriage of justice? If it were impossible to fake this, then it wouldn't be a substantial risk of a miscarriage of justice, right? So how do we figure that out? Well,
so I think on some level, I think that jurors probably mostly have social media accounts and understand that you could that anyone at any time could set up a social media account under the name Mac Brim and using, a random email address that they set up. That's essentially what the prosecution's theory was that Mr. Cordova had done, because it's not an account that's tied to his real name. I think that it's inherent in their theory that anyone could simply set up an account under any name.
And am I right that the Commonwealth had only a video of the face of the phone? This is not downloaded,
No.
with the usual whatever that thing is called, Cellbrite or whatever.
No, there's a frankly to me very odd sequence of events here where there's an allegation made in 2001. The police do nothing to retrieve any of the text messages until February of 2003, basically on the eve of trial. At that point, they re-interview both the alleged victim, who, a little bit of a side note, but she exchanged text messages with Mr. Cordova, and those were easily authenticated because it was a number that, they put in records from Sprint or whatever that traced it back to him. At that point, they retrieved those messages. They also had the mother just scroll through her phone while they made a video of her doing that. And so the messages that were ultimately admitted were essentially screenshots from that video. This is being done years after the messages were allegedly exchanged. And so if you think about an opportunity to falsify them, it was certainly there. It's not the case that there was this allegation and then the police immediately took the phone. It's also not the case that the police did what I would think of as a pretty standard practice where you do an extraction on a phone and then you're able to see, you're able to see the messages in more of their entirety. They also don't do an extraction on the alleged victim's phone, although she says that at Mr. Cordova's instruction she had deleted various messages and materials. They take no steps to try to recover those.
They do an extraction on his phone, though, and didn't find the picture. Is that right?
They did an extraction on his phone and found nothing.
I thought it was a new phone. It doesn't say something like that?
There's a suggestion that it's a new phone, but they don't. There's essentially no evidence because they're not able to recover anything, and the theory is that it's because it's new, but there's no evidence of what would have been on an old phone. The phone that they extract, they find nothing. And that's, it's less far away in time from the allegation, but it's several weeks later. It's, I believe in mid-December, and so it's almost a month after the allegation is made that they go to his apartment and seize his phone. One thing that I do want to say, Your Honor, is I think that you asked about a substantial risk of a miscarriage of justice, and I think that goes not just to was there a realistic risk that someone could have falsified the messages, but also to, how important were the messages to the case. I do want to note that the Commonwealth's opening began with the messages, the Commonwealth's closing both began and ended with the prosecutor quoting specifically his alleged statements in the messages, his alleged responses to the victim's
The
mother in those
messages are the only confession in the record?
So the alleged victim's mother also claimed that he made similar statements to her in person.
I see, but this is the only corroborated.
Yes, this was corroboration. It uses very similar language to what he said to her in the immediate aftermath of the allegation. If there are no further questions, I do see that I am essentially out of time, and so I will rest on my briefs.
Thank you very much. We will hear next from Attorney Kosh.
Good morning, Your Honors. May it please the Court, Kyra Kosh on behalf of the Commonwealth. On that last point, as to whether there was any other inculpatory statements by the defendant admitted at trial, the victim at transcript site, volume 3, page 88, testified that on the way to the police station, the defendant said he did not intend to hurt her in any way. So the text messages that were admitted essentially are pretty much the same as that one statement admitted through the victim's testimony. So as for the Facebook messages,
Remind me, doesn't the victim also have a conversation with him regarding whether he's going to turn himself in?
correct, yes. The victim was there as they were on the way to the police station, and essentially given the same reasons that were part of the Commonwealth's proof of force as part of the forcible rape charge, that she was essentially groomed by this man who she saw as her father figure. She said that she didn't want to see him hurt, which is why she pleaded with him, like, no, don't turn yourself in. So going to the confirming circumstances, authenticating those Facebook messages, there are plenty, apart from just the content of the messages, where it's very clear that the defendant is saying, please forgive me, I don't want to go to jail for this, the same statements that he made, that he didn't mean to hurt her, et cetera, as well as the timing of the messages, that they were sent the morning after this disclosure and as he was, as they went back from turning himself in at the police station.
But even if we assume that the evidence is sufficient to allow this in, that is, it's sufficient for a jury to find by preponderance of the evidence that he wrote this, there's no instruction. Do you think there has to be?
No. I believe the defense in their reply brief said that I conceded error on that issue. I did not concede error. There is no case requiring such an instruction in all instances. In
So
fact,
let me ask you, is such an instruction required?
no. The language of the cases is that such an instruction is the better practice, but it is not required. And in fact, a defendant had raised this issue before a panel of this court in 2020 in Commonwealth v. Tirado. It is an unpublished decision, but the court in that case, the panel in that case wrote, we have not found, nor has the defendant pointed us to any cases in which that says that such an instruction is required.
What instructions are required?
As for the Facebook
In a
messages?
criminal case, what does the judge have to tell the jury? The lawyers have fallen down on their job and they forgot to present anything. And so now the judge has to instruct the jury.
Well, relevant to this specific issue, the judge does have to instruct that it is the juror's duty to assess and weigh all the evidence, which instruction was provided in this case, which they were instructed that it's up to them to decide how important each piece of evidence is, whether it's testimony by a witness or an exhibit, that they're not required to believe something simply because it's an exhibit. They are the sole arbiters of which evidence they choose to believe or not. And they're also instructed that they should consider whether a witness does have a motive to testify in a certain way, which goes to the evidence of bias issue, as well as whether there was anything else that they believe could have influenced this witness's testimony, whether they were deliberately lying or making an honest mistake. Instructions like that certainly would be required because that goes straight to the juror's duty to decide whether the defendant is guilty beyond a reasonable doubt. So,
Do you know if juries are instructed routinely with respect to authenticated material, that it's their judgment?
I do not know the answer to that. Again, it is the better practice, but there is no such requirement.
Which
in any
case says better practice?
That is Foster F., which is 86 Mass Appeals Court 734. It's a 2014 case.
86-734?
Correct. And in Commonwealth v. Gilman, the same issue arose, and they cited Foster F., saying, again, that would be the better practice. It's not required.
If it were required, let's talk about substantial risk of a miscarriage of justice.
I don't believe there is a substantial risk of miscarriage of justice, given the sheer amount of confirming circumstances in this case that demonstrated that the defendant was the author of those messages.
But I know nothing about tech, really, given my age. But it doesn't seem like that hard to me to create a complete fake Facebook conversation. And presumably, the mother would know exactly what phrases to put in.
Sure, but as the court said in Purdy, the seminal case on this issue, the defendant's claim that someone may have authored the messages goes to the weight of that evidence, not their admissibility. It does not go to whether there is...
No, but this isn't about admissibility. It's about there's no instruction.
Correct.
I mean, it is, I understand you're arguing admissibility, and that's a live issue here, but...
Correct. And again, there was other evidence related to the defendant's statements that were similar to the ones here. So that is why there is no substantial risk of miscarriage of justice there. So to move on to the evidence of the Target incident, as Justice Desmond correctly pointed out, there's really minimal probative value, if any, as to this happenstance meeting at Target where Ms. Diaz is coming out and SR is walking in, and they have an altercation.
But you put into evidence this statement that between September and the time of the report, they had made peace.
So the comment...
And that goes directly to the allegation that the basis for all of this was retributive.
Sure, but that also discounts the third incident that was admitted, which is in between that time period. It was a few weeks prior to the disclosure where SR told the defendant's cousin that she was tired of the defendant cheating on her and that she was going to pay him back, in quotes.
I see.
So the argument that the defense makes about how the Commonwealth was able to mislead the jurors about their relationship, I believe that the evidence of that incident wholly discounts that. And it was also... The Target incident was 8 months after that at peace statement, which was, I believe, September, like during the time, September, November, so 6 to 8 months after the fact.
Well, but it would show that there was still anger there, that they hadn't made peace. I mean, I don't know how valuable that is, but it seems relevant.
Perhaps, but it's relevant to how she feels about Diaz.
Well, it's relevant to whether they have made the kind of peace that's peace, because they haven't.
Sure, but Diaz was not a testifying witness in this case. It was the defendant was cheating on SR with this woman, and sure, they may feel some type of way about each other, but what does that have to do with whether the victim fabricated her allegations against the defendant 6 months prior to that date? And this isn't a case where all evidence of bias was excluded. The only cases that I've found that have considered exclusion of impeachment evidence reversible on this issue of bias has been when all inquiry has been excluded. That's the Vardinsky case, the Nicholas case. And had the judge done that, excluded all of these incidents where SR accosted the defendant or Ms. Diaz about the cheating, then sure, there would probably be reversible error here, but that is not the case. The issue was more than sufficiently aired. There could have been no doubt in the jurors' minds that the defendant had cheated on her and that she was so upset that she had gotten sick and lost weight from it.
Did SR terminate her relationship with the defendant on the date of the disclosure?
I don't believe that's clear from the record. I think one could infer that based on the text messages, where I believe she says something along the lines of, it was one thing with the hose, but this was my daughter, and how he's dead to her.
Do we know anything about the relationship between the defendant and, I'll say, BD after the disclosure?
I'm not sure if that's clear from the record.
Like, did he go move in with BD?
What was that? I'm sorry.
Like, did the defendant go move in with BD after the disclosure?
I'm not sure, Your Honor. I can't answer that question. I don't believe it's clear from the record the status of that relationship afterwards. So moving on to the motion to dismiss issue, there's no substantial risk that the defendant was convicted of unindicted conduct. He was charged with committing essentially multiple acts on diverse dates between the victim's 13th and 14th birthday and 2020, the date of the disclosure, as part of a continuing course of conduct. And this is constitutional. The dates and times of the assaults need not be precisely alleged in an indictment. And Barbosa explicitly limited its holding to situations where the indictment refers to a single act on a specific date, yet the grand jury were presented with two incidents on that one specific date, which were separate incidents. I believe in that case it was a drug transaction with two different buyers on the same date. And Barbosa also said its holding does not apply to indictments such as the one in this case, where the indictment alleges a continuing offense occurring at several times and places over a period of time. So as for the duplicative convictions issue, the court should not overrule its decision from 2022, just 4 years ago in Foreman, that rape of a child aggravated by age difference and forcible rape of a child are not duplicative offenses, because each requires proof of an additional element that the other does not. The concrete issue in Walker that the holding was based on in finding that indecent assault and battery on a child under age 14 is duplicative of rape of a child is because it is logically impossible to be under the age of 14 while being over the age of 16. It is a strict application of the elements test. But the issue in that case is slightly different than the one in this one, where the issue was whether the judge erred in giving a sua sponte instruction on the lesser included offense so that the jury could convict if they did not believe that the defendant had actually penetrated the victim. Whereas here, the indictments were for the two separate offenses, and the defendant was convicted on both. So for those reasons, I don't think the defendant's convictions were duplicative. And in case, if this court has no further questions, then I'll rest on my brief.
I see no further questions. Thank you. Excellent arguments by both of you. Thank you very much. Very helpful to us. The next matter is number 25427. And this is Commonwealth versus Suarez. And we will hear first from Attorney Dunn.
Good morning, Your Honors. May it please the court, Courtney Dunn, on behalf of Mr. ORTIZ Suarez, who I will note is watching via YouTube today.
Can you move the mic a little closer to you? Thanks.
I've heard this before, my soft-spokenness, so thank you for... So today I would like to focus my argument on the error which deprived Mr. ORTIZ Suarez of a fundamentally fair trial, the admission of prior bad act evidence. The admission was error for 3 reasons, any one of which requires that his conviction be reversed. First, the prior bad act evidence was admitted for an improper purpose. Second, the volume of the prior bad act evidence overwhelmed the evidence of the charged conduct. And third, that the risk of unfair prejudice by the prior bad act evidence outweighed any probative value.
So let's talk about point 2. Point
No,
2, the
okay.
second thing. You said it was,
The volume?
no, I'm
Oh.
sorry, maybe it was point 1. You said it was admitted for an improper purpose.
Yes.
You don't disagree that sometimes prior bad acts is permissible to come in?
I don't. They do have relevance and may be admitted for a proper purpose if that relevance is proper and that the risk of unfair prejudice does not outweigh any probative value.
And when we talk about the bad acts, are we limited to just the text messages, or are you also talking about the pictures?
The photographs, yes. So it would be all 95 pages of text messages and 4 photos it could not be authenticated if they belonged to Mr. Ortiz Suarez.
Is it, I'm sorry, go ahead.
So those came in to show the pattern of him coming in the white SUV or whatever the white vehicle is, having a brief meetup, and was that the purpose?
So the trial judge allowed the prior bad acts to come in for 4 different purposes. 1 for pattern of conduct.
So that would include a quick stop at a mini mart, convenience store in the white SUV, that pattern.
Right, and that was an error of law. Pattern of conduct and pattern of operation is usually used to show a distinctiveness to a defendant's acts, a uniqueness of conduct to prove identity. And in this instance, the error of law was the trial judge, as you just said, Justice Desmond, allowing these text messages to come in to show that a basic pattern of negotiation.
Would it have been permissible if they had showed that all of the other previous buyers also got their drugs in a solo purple cup?
I think that in that instance, that could have gone to uniqueness and distinctiveness, but it was still error to admit them when you weigh the volume.
Doesn't it have to be an issue that's live in the trial?
For the probative value and the relevance.
For past bad acts to come in?
Yes.
Right, so there's no dispute, so far as I can tell, that the defendant was the person driving this white van who had some kind of interaction with the defendant, purple cup or no. And the only question is, did he sell him drugs? Now, I guess maybe you could bring in past purple cups to show these must be drugs sold by him. I don't know if it's really exactly about identity. Maybe it is. But I thought, part of the problem I'm having with all of this is I thought it had to be live issues. It's all fine and good to say his motive was to make money, although, please, why do drug dealers sell drugs? That's not a live issue, right? Everyone knows why they do it. They do it to make money. I agree with you. So yeah. I'm just trying to figure out what has to happen, because, of course, I've never seen a case where 10 past drug deals are brought in when what's charged is a single hand-to-hand transaction.
It was actually 34 uncharged transactions.
Well, how about in the transcript?
In the transcript, it was 18 that were read aloud by Chief Carney. And I do agree with you, Justice Rubin, that Mr. Ortiz Suarez pled not guilty. He did not say that he wasn't at the 3N convenience store. He did not say that he was in Salem.
He did say that he hadn't met up with the buyer. He did say that, right?
He said that he hadn't met anyone.
Whatever, that includes the buyer.
And
when they stopped him, he said, no, I didn't just meet up with anybody.
That's what Detective Reagan reported.
So here, the court put some temporal limits on how far-reaching these bad acts could go. And in this case, they said 2 weeks, which on its face seems reasonable, 2 weeks, versus their cases, I think they said 8 to 10 weeks wasn't too long. And so, but the volume, for a case where no drugs were recovered from the defendant, right?
Yes.
And what other evidence did they have against him?
So it was all circumstantial. It was that the detectives witnessed what they believed was a transaction between Mr. Ortiz Suarez and Mr. DeVoe. They pulled him over.
No, I understand. And so, and they also said, I think the evidence against the defendant was that he had money that was grouped in certain amounts, 40s and 60s and 80s or things to that effect, right?
Yes,
Okay,
that's
but the
correct.
pictures, did they show that?
No, the pictures just show very large stacks of money. So,
And although it was 2 weeks, which I think is a reasonable period of time, given the volume of the interactions during that 2 weeks, perhaps a couple of those interactions would have been permissible, but does the 2 weeks, that limit, did that have any real impact under these circumstances, I guess is the question.
no, it didn't. I mean, the 2 weeks, despite it being, as you pointed out, Justice Desmond, a short temporal time limit, the volume of transactions that were in those messages was vastly outweighed the instance of one incident of charged conduct. And none of the messages were between Mr. Ortiz Suarez and the other, Mr. DeVoe.
And when they stopped the buyer and they asked him, who they know, Mr. DeVoe, right?
Yes.
They know him. Do they specifically ask him about, did he get the drugs from the person in the white car?
No, they made, Detective Cunningham testified that he did not ask where Mr. DeVoe bought the drugs or from whom in cross-examination.
Question was, like, would you just get, or
Detective Cunningham testified that he asked, where are the drugs you just bought, John?
that you just
But Mr. DeVoe responded right there, but that doesn't mean that he adopted the statement of Detective Cunningham. He was
And
answering
also
questions.
just could mean, look, he's a drug addict. Whatever he's got might be something he just bought, but that doesn't mean he just bought it 14 seconds ago from
Exactly.
the guy in the SUV, although.
And he was on the street that he lives on, one house away from his residence.
And of course, throughout this whole time, when we had the unfortunate death that had occurred that day,
Yes.
and the police were particularly in that area to look for this type of conduct and behavior. And notwithstanding that, they still never actually saw the drugs pass from the defendant to Mr. DeVoe, or a purple cup pass from the defendant to Mr. DeVoe, or even Mr. DeVoe put a purple cup of drugs down on the ground where they were eventually discovered by the police or pointed out by Mr. DeVoe.
That is correct. And I know that the case law says that it's not necessary for detectives or police officers to see the exact exchange because of how small. But as you pointed out, Judge Desmond and Justice Rubin, they were in a purple cup. And allegedly, Mr. DeVoe was under constant surveillance by 3 different officers, and no one saw this purple cup in his hand.
But the only issue is probable cause to arrest, right? You're not saying insufficient evidence to convict.
Yes.
So it doesn't have to be proven. There just has to be probable cause. And maybe the combination of he just bought drugs and he lied about meeting anyone there, might be probable cause, even though it probably wouldn't be sufficient to convict.
I would disagree and say that it was absolutely reasonable suspicion, but I don't think there was probable cause to arrest. And I know that in its brief, the Commonwealth, when it went from reasonable suspicion to probable cause, brought up that it was a furtive action, which I think it misunderstood the quickness of the transaction. Doesn't go to furtiveness, it's the action, let's say.
Well,
Furtiveness, is that what you're saying? Furtiveness?
Yes, thank you, I apologize.
So, yeah, but to me, I think there's reasonable suspicion after seeing what they think is a hand-to-hand drug transaction. So now let's see what adds to that. Say he has $516 in his pocket broken up into groups of 20s, 40s, and 80s, or whatever they were.
And two
The
phones.
guy, what? And 2 phones, although I have 2 phones, but that's another
So do I,
story.
Your Honor.
The person who is the putative buyer is asked where the drugs you just bought and has some drugs he just bought, and the defendant suspect at the time denies having met anyone there when whatever happened, it was a meeting between these 2 people. I mean, you think it's still only, I mean, I guess that has to be your position, it's still only reasonable suspicion and but that's a few different
But I'll
evidence.
agree that it is not sufficient evidence to convict for
I
distribution.
agree with that.
So, thank you, Your Honor. And so I'll see that my time is running short, and that I will just quickly go to remind the court that there's the weighing of evidence. It's the probative value versus the risk of unfair prejudice, and as how the justices have pointed out today, the sheer volume of the text messages and photos, as well as their similarity to the conduct charged, it actually substantially outweighed any probative value.
It doesn't have to substantially outweigh, right? So this is a special balancing test because past bad acts run such a risk of unfair prejudice that instead of our ordinary test, does the risk of unfair prejudice substantially outweigh the probative value? We just ask, does the probative value outweigh the risk of unfair prejudice?
Yes, it's a
It's a more
simply
pro-defendant.
A more rigorous test. I just was pointing out that in this instance, it does. So it meets the higher standard. If there are no further questions from the justices, I
see.
would rest on my,
I see none.
I would rest
Thank
on
you.
my brief.
Thank you very much. We will hear next from Attorney Cohen.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. I think I can dispose of the first issue fairly quickly. I would argue that there's probable cause to arrest the defendant at the time he was arrested, and that the facts of the case as elicited at the motion to suppress hearing compare pretty closely to those in Kennedy. And I would just note that, to clarify, I did not argue that there were furtive movements. I argued, as in Kennedy, that the brevity of the interaction was comparable to the furtiveness of the movements. I would guess that the court would like me to focus on the second issue, so.
The pictures and the volume of messages. It seems pretty difficult for anybody to see the pictures and the volume of the messages and not have any reasonable doubt that the defendant's a drug dealer, even if you didn't have anything to do with Mr. DeVoe.
So I would concede as to the images, the probative value of those images is fairly low, and I think that does go to I think the reason why the probative value is so low kind of goes to my prejudice argument. I think there was a reason the prosecutor wanted to bring these in, and that was because of the large amount of money found. But I would also agree that former police officer Carney, in testifying about the images, said that these images came from the Instagram cache of the defendant's phone, not his camera roll. And I think it was unclear in his testimony whether those text messages were transmitted by or received by the defendant. Additionally, the money wasn't connected I think because it was found on the Instagram roll, it wasn't connected to the text messages, and it wasn't connected to any illegal activity. It wasn't something that was raised in the closing argument, and I think...
Wasn't grouped in 40s, 50s, 40s, 60s, and 80s?
Correct. It was very dissimilar.
The way that was retrieved from the defendant on the day of the incident?
Yes, so I would concede that those probably shouldn't have come in, but I think because of their low probative value, and also the instruction that there was no prejudice as to the images.
Standing alone. Couple that
Yes.
with the volume of the text messages.
So I do acknowledge that there were 95 pages of text messages, but what I would acknowledge that Mr. Carney read a significant number of the text messages aloud. However, in the 95 pages of text messages, while there are certain quite damaging messages between the defendant and these unknown individuals.
They do talk about brown and hard and
Yes.
the type of drugs. I get that.
Many
Was
of
that
the-
the argument at trial?
I'm sorry.
The purpose of the messages?
So the purpose of the messages, as argued by the prosecutor, I think in closing, she touched on the messages and she argued that the messages should be used for pattern of operation, motive, and I think knowledge is what she argued in closing.
And intent.
I don't think she specifically argued that in closing, but it was a reason
Oh,
that
no,
the
but I think the judge
Yes, the
said that
judge-
they were
yes.
admissible because of intent.
Yes.
So I know that Justice Desmond is focused on the quantity. I don't think one of these probably could come in. So let's go through that.
Sure.
Pattern. Did the defendant text the...
None of the messages were between.
I didn't ask you that. I just asked you if there's any evidence that the defendant had a text back and forth with the
No, there's no evidence of that.
buyer. Okay. Is there any evidence that the buyer used the words brown or hard?
No, but Sergeant Troy did testify that brown and hard are the words for the drugs that were found.
Yes, I don't know which way that cuts. That seems to cut against you because he didn't use those words, but they were used throughout these text messages.
Well, I don't think there wasn't any testimony from the buyer or from the defendant on the drugs. So I would just say that the fact that
So this doesn't show the pattern of operation. I thought you actually conceded the identity piece of this in your brief.
yes, so I would agree that in the case law, the notion of modus operandi, pattern of operation, course of conduct, all those things kind of go to a signature.
And there's nothing like that.
And that's not here. But I think the judge understood that. He was categorizing it when he was weighing the evidence as modus operandi. And I think that when he was talking about this going to pattern of operation, I don't think he was necessarily thinking of it in terms of the way the case law kind of uses those
Okay,
words.
so are you saying that's error?
No, because my position is that in Butler, this is discussed, that the label or the categorization as far as this weighing goes is less important than the permissible use that's being argued. And in Butler, I can't recall the exact site, but it is footnote 6. The court compares how evidence might be admitted for motive in certain cases, and in other cases it might be categorized as intent or it might be categorized as
Okay, so let's go through those other ones. Motive. Is that a live issue?
So what I would say, Your Honor, is while the judge categorized these things as motive, pattern of operation, intent, and knowledge, I think what was understood was,
Understood by who?
I think between the Commonwealth, the defense counsel, and the judge when they're arguing whether or not these things should be admitted, was that we're talking about whether or not the defendant was intentionally in the 3N parking lot and intentionally meeting with DeVoe.
I don't understand what you mean. How do you unintentionally drive into a parking lot?
Well, I think it was the defendant said first that he didn't actually interact with anybody. He also said he was just going to the store to buy some tickets and a soda, and then his
Okay,
fiancée
so he
called.
intentionally drove into the store.
And I think from his testimony, or sorry, not his testimony, what he said to the police, there was an inference that even if he did meet this person Mr. DeVoe. It was not intentional. It wasn't a purposeful interaction.
And was there anyone in those text messages, I don't know if it matters if there was only one, where he said, meet me at that, whatever it is, Quickie Mart, whatever
No,
place it was?
but there was, the defendant arranged to meet individuals at various public locations. I think there was a McDonald's, a Walgreens.
That pretty unusual for a drug dealer?
No, and that's why I wouldn't argue that this is modus operandi as defined by the case law. But I think what I would argue was understood as far as the Commonwealth's argument and the judge's admission, while he did, I understand financial motive is a tough one, but I think it was whether or not this defendant was purposefully interacting with the individual, or was this just
The accidental hand-to-hand sale.
what, I think
I've
in
never
closing,
seen that either.
Well, in closing, defense counsel argued that, Mr. DeVoe does all sorts of things around town. And I think the implication was Mr. DeVoe could have just been, asking for money, saying hi, whatever. Like there was, because the defendant had no drugs on his person, and because at trial there was no evidence admitted about the overdose death or anything that Mr. DeVoe said to Cunningham. It was purely the drugs are found by his feet.
So I'm just going to ask you a tough question. As you stand here right now, do you think that the probative value of that evidence outweighed the prejudicial value against this defendant, who no drugs were recovered on him in his car? He had 2 phones, who cares? And money's grouped in 40s, 60s, and 80s, whatever it was, up against pictures of him just with vast amounts of money in all of those text messages.
It is the Commonwealth's position that the probative value did outweigh the unfair prejudice. I do understand the volume it's hard to get around. I understand that. If there are no further questions, I will rest on my
No,
brief.
thank you for an excellent job, both of you, really. The case is submitted. This brings us to, I believe, our final case of the day, although, yeah, it is. Our final case of the day is number 25-384, and this is Michaelelsson versus Talbot. We will hear
morning.
first
May it
from
please the
Attorney
Court.
Fierst, yes.
My name is Frederick Fierst from Fierst Bloomberg Ohm in Northampton, Mass. And I must say, watching you all this morning, I have to say thank you for your public service. This is a tough job you've got. I'm glad we're the last case for you. This is an unusual case, in my opinion, because we have so many factors that are involved, which cumulatively, I believe, require a new trial. And if not a new trial, then some sort of reopening of the proceedings to take some additional evidence, which is allowed under Rule 59. And the 9 factors that I focused on are the ones that are on page 39 of my brief. And they are, first of all, that my client, Laura Talbot, was unrepresented by counsel during all of these proceedings in the trial, and this was not her choice. She was forced by the judge to go to trial without counsel. I'm not exactly sure why. The record doesn't seem to indicate.
No, it appears to me that the conversation about when this trial was going to take place started back in May, and that the parties had come to an agreement. They submitted a separation agreement, and for whatever reason, your client decided that she no longer believed that that was an equitable, fair, and reasonable agreement and did not want to go forward with the settlement. And so it started in May, the conversation about when the trial was going to be scheduled. But the record doesn't give us what occurred at that hearing with respect to scheduling. It doesn't tell us in June what happened at the motion to withdraw and the reasons for that. All we have is the trial transcript. And why is that?
Well, as you probably know, I was not counsel for, obviously, for Ms. Talbot at the trial because she did not have counsel. But my understanding is that the pretrial conference that was held in June 15th addressed the resignation of Ms. Talbot's attorney, and what Ms. Talbot had said, and she said it the day after the settlement was signed, was that her attorney had fallen down, broken her hip.
You would agree with me, we don't have that. You're just telling me what you,
No,
you believe somebody else said at the hearing.
Okay, I'm sorry. We don't know what happened between
Isn't that
June-
important, that we know what happened in May and in June, and what the judge said to these parties about whether or not the trial was going to take
I don't believe the
place?
judge said, there was a motion made on June 29th to postpone the trial so that Ms. Talbot could get counsel.
Well, there was a
and-
status in June, and that was when the trial dates were set.
And the trial dates had been set, and the
Well, I
motion
imagine
was
there was some
denied.
conversation at that point about what was going to happen, that the trial was going forward. They were in a second position. I mean, that we have a single calendar in the probate court, and the judge is managing her schedule, and so she gave them one date and said, you're in second position, and if that trial settles, you're going to go forward. It's in the pretrial order. So I would imagine that there was some conversation that day about the procedure, but that's not in the record.
I don't have any knowledge of that, and it's not in the record, you're correct.
Somewhere it says, maybe it's in the motion to withdraw, that successor counsel had been identified already or something like that?
There were two instances of successor counsel being identified, and the first one was the withdrawal of Attorney Dunn. She said, my client and I have had different opinion as to how to proceed, and she has either obtained or conferred, I don't remember what it said exactly, successor counsel. And then what I understand...
Well, it might be important what it said.
Yellow, right?
Pardon me?
Attorney Lippiello, is that how you pronounce the person's name?
Lippiello, correct.
Although that person never filed any notice of appearance?
She never filed an appearance. My
Have
understanding...
any affidavit from predecessor counsel, right? That's done,
That's correct.
corroborating anything, any of the representations that were
Absolutely,
made
yes,
by Ms. Talbot?
yes. I'm not sure of the question, if what the question is here.
Well, I believe we're talking about what's in the record that might support the argument that the motion to continue or the motion for adjournment should have been allowed. And to some extent, that must go to the merits of the argument that is lurking here, which is I couldn't find anyone else.
That was not ever articulated to my knowledge.
Well, I
and,
agree with that.
You know, I don't know
You
what
asked
happened.
for it, well, there was no counsel. Was an evidentiary hearing sought on the motion to continue? So
sorry.
that an evidentiary hearing sought on the motion to continue in June, on June 29th, so that,
I
for
don't
example,
believe so. I believe that Ms.
could
Talbot went
have
to
said
the
to the
court.
judge, but I can't find anyone else, or I've called 12 people, or anything like that.
That never came out. To my knowledge, that never came out. My understanding is that Ms. Talbot went to the Greenfield court and sat down with one of the court assistants and wrote out a handwritten motion. And what she said there was, I've obtained Attorney Lippiello. She's going to try and settle the case. And if she isn't, she can help me try the case, but not until January. That's all we have in the record. And I don't know if you can blame...
I mean, isn't it true, though, that in the probate court, you're entitled to counsel, but you're not you're not entitled to counsel, and you're certainly not entitled to the exact counsel that you want on the day that you want them. And that's what it seemed like she was saying, was that she was really trying to sort of jam up the schedule and say, and to force the trial to January.
I'm not sure, Your Honor, how you would say that's what it seemed like she was saying. I mean, as I've pointed out in the brief, she had about $1,000 in the bank. She's in Greenfield, where there aren't a lot of lawyers. And she did find somebody between the denial of her motion and her returning to court for the trial. And that somebody couldn't be there.
Wait, isn't that, I mean, we don't know. It seems like that's the same somebody as on June 29th. I don't know for sure, because it's never mentioned.
Yeah.
But like the person on the 29th, this person couldn't do a trial until January. Now, I have no idea in Greenfield how long it takes to find a lawyer, how long it takes a lawyer to prepare for a trial like this, how booked people's schedules are. I know nothing about that. But you also haven't given us anything about that.
Yeah, I don't know what I can give you, since I feel I'm constrained by the record. You know, I can't create something, and I can't add a supposition, and
well,
the
there
judge...
was a motion for relief from judgment.
Well, I did make that motion,
but without affidavits from experts saying, you know, or people in the community saying, like, you can't expect to get someone to...
No, because that was not the point of my motion for relief from judgment, really. I mean, I think you can fault Attorney Lippiello for not putting in a limited appearance. I think you can also fault the judge for inquiring further of Ms. Talbot. Well, have you looked, and who did you find? And if you are going to go pro se, maybe we can get you limited assistance, or you can meet with somebody in the court to go through the procedures. You know, the second point that I was going to get to is that when she showed up for trial on the first day of trial, she did not have the witness folders. She did not have any exhibits.
But it didn't, I mean, it seems that it seemed to me from reading in the transcript that she took her file and gave it to Attorney Lippiello, and then left her file with her there. Like, she just did not bring it to court with her. And she says during the trial, you know, as they were sort of wrapping up, well, and that she was going to do proposed findings with her, and she had the file.
That's correct. I mean, I cannot explain that. I can only point to what happened and say this was, in my mind, evidence that she was not competent to be appearing pro se and to be addressing...
Well, no pro se litigant is competent that I've seen. Maybe if they're a member of the bar, but I've never seen a pro se litigant who's a competent lawyer, not one. That's why you hire a lawyer, right? I mean,
well, that's true. I just think, and I think it was pretty clear as the trial started, that Ms. Talbot was really just completely confused and anxious and clueless about what to do and how to proceed.
Ms. Talbot is a smart lady. Ms. Talbot is not a dumb person, right? I mean, she's a teacher in a high school?
Elementary school. She's an art teacher in elementary school.
She's a teacher in a school, right?
Correct.
And for some period of time, she was like the executive assistant to the stay-at-home mom, and I don't mean that disrespectfully, to the chief of surgery. She managed the 100-acre property. She took care of all the bills and utilities. She taught the kids. She managed the household. That's a huge responsibility. That's something that not just anybody could do. And she managed those things effectively.
That's true if you believe what she said about what she did there. But, you know, learning disabilities don't mean you're stupid. They don't mean that you don't have intelligence, that you could be
well,
very
the motion
smart.
to continue didn't say, right, you show up on the day of trial and say stuff. You can see why a judge might be like, thanks, there was a time and place for that, but we're having the trial. But she does make this motion 15 days after the trial date is set. It doesn't say, and I cannot represent myself pro se. I have no idea how to do this. Now, I gather in both cases, she says something like this, I think, at the trial. I thought you'd let me get, have the time to get a lawyer.
She says that at the trial on several occasions. I can't represent myself. This is very difficult for me. But that is really only a part of our case and our argument because, you know, there are several major factors here that where I think the judge made some mistakes. Despite, you know, a tremendous effort to spell out her Section 34 findings. One is this idea that Ms. Talbot had a $250,000 art collection, that it was her choice to sell or not. And, you know, I have, you know, have some very substantial artist clients who have art in Museum of Fine Arts as you walk in, and they can't sell all their work. And
She attempted to sell it, though? I mean, unless she had sold some art.
She'd sold she sold six pieces for $21,000.
Well, that's pretty impressive. And she's a good artist, right? She had received an award for being Artist of the Month or something.
I mean, I actually have seen one of her exhibits, which is how I got to sort of acquainted with her art. But you know, whether she's a good artist or not.
Well, had she attempted to sell any of the other remaining pieces?
Yes, she had 3 gallery shows, private shows, and she put in an affidavit that there was not one single offer on any of her pieces. And she had a website, which both Dr. Michaelelsson and she thought was great, and nobody was interested. And the judge misconstrued when she said, I love my painting and I'm going to keep doing it. I don't care if I can sell it or not. The judge misconstrued that as meaning she chooses not to sell it. That's not the case. She loves painting and she's going to keep doing it whether her art is sellable or not.
What do we make of the fact that she agreed that the value, if she was to sell it, was $250,000? We have issues of personal property.
If sold,
Your
Honor, if sold, if sold.
That she wanted to put, she insisted that that phrase be put in, if sold. So she was agreeing that if she either made the effort or was capable of selling them, that it would procure, if she could procure the buyers, that she could sell that.
I'll let you answer that.
Sorry, I mean, she couldn't sell her art, but if they were sold, she would agree that they could have generated that amount of money, but they weren't sold. They were never sold. She could not sell her art despite her best efforts, and that's not on her. That's on art conditions and people who look at it. And the other point, if I may move on, because my time is almost up, the other point is that Dr. Michaelelsson testified to the fact that this was not an economic partnership from 2009 to 2015, and the affidavits that were attached to the post-trial motion, which I prepared, demonstrated that there was a high likelihood that that was not true, and the judge, I believe, should have opened up the hearing, taken some evidence, looked at that, and made a decision as to whether Dr. Michaelelsson was telling the truth or not, because I think there was enough evidence that she was not telling the truth. And I'm looking at the totality of these circumstances and saying that they satisfy the Section 6 of Rule 60, which says, you know, in the interest of justice, that all of the different factors that happened with her in this trial resulted.
Doesn't the judge talk about why she didn't go back to 2009?
Yes, she said there was no evidence presented, not sufficient evidence. My time is up, and I'm
You can answer this question.
There was no evidence presented other than the two parties' testimony, and I think that for Ms. Talbot, she had no witnesses, no evidence, no exhibits. She knew nothing about cross-examination, and I think you're being pretty harsh on her, with all due respect, to say, well, she should have put other things in her motions, et cetera. I don't know how she would know that.
On the first day of trial, she was told specifically that she could bring her ex-wife in. The ex-wife was on the witness list, and the judge said, then she can certainly come in on the second day.
The ex-wife was very sick, and that was in the affidavit, and she could not bring her in.
I think the affidavit says is that she refused.
I think that was Sarah Hill's affidavit that she was suffering.
She said she refused to come in.
Was that Laura or was that Sarah? I thought, you know, frankly, that Sarah was unwilling to come in because she was sick at that point. And I think she was unwilling to come in because Laura was not represented by counsel, and she didn't feel she'd be protected at that point. My time is up. If you have no further questions, thank you.
Thank you very much. We will hear next from Attorney Williams.
Good morning, Your Honors, esteemed panel. Attorney Heather Jill Williams on behalf of Holly Michaelelsson, who is here in the court to watch the hearing on today's date. I first wanted to address one of the issues that
Can you move the mic more toward you? I don't know what's going on with it.
Is that
today.
better?
Yeah.
Okay.
Thank you.
I first wanted to address one of the issues that the panel brought up about this issue about what happened at the prior motions to continue. And my brother indicated that he couldn't provide that record for the court. He absolutely could have. There is a record. There were transcripts of those hearings. Part of that record was included in the docket sheets where the motions were denied. I recognize that this panel doesn't have the benefit of the colloquy which occurred on the days that those motions were denied. However, for my brother to suggest he couldn't provide the information, that's simply not the case.
So they're in the record, but not in our record appendix.
They're not in your record. There certainly is a record. For the record transcripts in the lower court of the hearings on the dates of the motion to continue are absolutely part of the record. And I was curious I didn't understand why that wasn't included when the record appendix was being developed, because it would stand to reason if part of the argument is I was repeatedly denied reasonable motions to continue, each of those records would have been produced where Your Honors would see why those were denied. The next piece I would like to focus on is something that the court did raise relative to how in a civil matter such as a divorce, parties are not entitled to counsel. And a lot of the...
They're entitled to retained counsel.
They are entitled to have they have the right to counsel, but it is not as it is in a criminal case where there's ineffective assistance of counsel.
They're not entitled to appointed counsel if they can't afford one.
Correct.
I agree that on appeal, there's no ineffective assistance of counsel claim because it's a final judgment. But they're entitled to retain counsel of their choice.
They are, and Ms. Talbot was afforded those opportunities, and particularly in the probate and family court, we do have, as my brother mentioned, limited assistance representation. And had Attorney Lippiello filed a limited assistance appearance simply to continue the trial and say to Judge Sandman, I'm here, I'm willing and available, and I will try this case. I just can't do these dates. Can we get a continuance? I think there might have been a different result. But what we had is a pro se litigant who kept telling the court, I'm going to get a lawyer. I'm going to do this. I just need another date. But we don't have the lawyer coming in who very much has the ability to say, with a limited appearance, I'm here, I want to help, I'm willing to help. That is a very different scenario, and that is not what occurred in this case. There was never independent evidence that there was a lawyer available, willing to work with the case, and in the background, we have an attorney that did withdraw, stating that there was some sort of a breakdown in the communication and in the relationship. That resulted in a trial that was supposed to take place in June getting continued until August.
Did you object to the continuance? Did you file an opposition?
To the one in June?
June, yeah. Motion.
I orally objected, yes, I did.
You orally
I
objected,
did
so
not
we don't
file-
have a record of that either.
Well, not in the docket, but if there was a transcript,
I understand, but we don't have that. You didn't ask to have it put in the record appendix either.
I did not, because it, quite frankly, is moot. My motion, the motion to continue the June date was in fact allowed, and the trial was continued to August. And so now we come into August.
No. On June 29, there was a motion to continue this handwritten motion.
Oh, yes.
I'm asking if you opposed to that.
I did.
Okay,
And that's
but only in orally, and that's in a transcript that we don't have.
Yes, Your Honor.
And I understand counsel for the other side didn't put it in, but you didn't ask to put it in either.
Correct. I also objected to continuing the trial in May, and my objection was overruled. And we
Okay,
were
I
continued
don't,
to
yeah,
August.
that's a different story.
So then what happens is when we show up for the first day of trial, Ms. Talbot, and I would suggest to this court in my experience, oftentimes pro se litigants do not bring their exhibit binders. They don't show up prepared, even though she had them all. On that day, and this is in the record, I volunteered. I said, I will give her my second copy I did
Okay,
everything.
you're not her lawyer.
I'm not her lawyer, but because I was aware of the standards of practice in the probate court and how there's supposed to be deference given to pro se litigants, and if with an eye forward that this might come up on appeal later, I volunteered and said, let me give her all of mine, let me give her all of my books, and we handed over, and then I operated at sort of not a huge deficit, but a deficit in that now I didn't have the copy for my client to look at while we were working. Then the court offered even further deference to Ms. Talbot when we took a break. We sat in the hallway with a probation officer, and then we went into their office, and this is in the record, and that is how that stipulation arose.
The question isn't whether she was treated properly as a pro se litigant. The question is, should she have been pro se, I gather, right? I mean, it's all fine and good to say once she was pro se, it was all done, I don't know if you want to say even beyond by the book. It doesn't turn her into a lawyer.
It absolutely does not, but I read in my brother's brief, part of it was that the special deference was not given to her, and I would wholeheartedly disagree because throughout the trial she was given instruction, she was given time to gather her thoughts, and in fact she actually did a fairly effective job of representing herself. As Justice Desmond pointed out, some of the factors which she presented as evidence, which was certainly not my client's evidence, that Ms. Talbot was a home manager and managed the children, that wasn't evidence that we put in, but that was evidence that Ms. Talbot was able to effectively advocate for herself.
Well, it's not an ineffective assistance of counsel claim, and I don't think any of us would hire her as our lawyer. So,
Right.
But can I ask you, can we skip ahead? There
Sure.
may be other questions about this lawyer or no lawyer part. I want to skip ahead to the arguments that are made in the brief about the decision itself. Do you agree that under the Reform Act, the Alimony Reform Act, that the question of need is measured by need to maintain the marital lifestyle?
I agree. However, it is a two-part analysis. It is need and ability to pay.
Okay, now let's talk about ability to pay.
Yes.
When, do you agree with this? If the joint money available to both parties is inadequate for both to maintain the marital lifestyle, there should be a fair sharing of the burden. Do you agree that that's the law?
I would not put it exactly in that manner.
But I think the SJC may have, so do you?
I think in this particular case, we have to look at all of the factors. This judge found this is a fairly short-term marriage with no children. When looking at
It's over 5 years.
It's still, in terms of how I've experienced the lower court, a shorter-term marriage, especially when there are no children. And this court balanced the fact that my client had legal obligations towards other children.
Whose fault is that?
Well, that is the state in which Ms. Talbot married my client,
Okay.
knowing that she had
So-
legal obligations
so
to other
I'm
children.
just trying to figure out, the judge says there's no ability to pay. This sets off a red flag in my head since your client makes $475,000 a year, and all she can pay is $200 a week, $10,000 a year to her ex-wife. Now, that seems, it's not a finding of fact, so I'm not going to say it seems clearly erroneous to me, but as opposing counsel points out, there is no mention of preserving the marital lifestyle with respect to Ms. Talbot in the decision. Rather, the decision says, essentially, your client is entitled to maintain the marital lifestyle. It says that. It says people might think these are luxuries, and I'm going to say that pool maintenance, horse maintenance, 5 BMW maintenance, housekeeper, other things are mentioned. And I'm going to say, yes, most people would think those are not necessities of life. They are luxuries, which luckily for your client, she can afford. But they don't make her unable to pay because they are luxuries. And there's no discussion of the marital lifestyle, except it says she's not going to have it anymore. Well, why does one get it and the other doesn't? And then she gets alimony. It says this isn't the sole reason, but so she can keep her studio open. The need she has isn't to keep her studio open under the statute and the SJC cases. It's marital lifestyle. and there's no mention of it in the opinion, don't we have to send it back for consideration of that factor?
So I think there was consideration of the marital lifestyle. And the fact that during the marriage, the only wage earner was Ms. Michaelelsson. And then during the separation, Ms. Talbot got a job making a substantial income with the right
How
to...
much?
I think she was making about $60,000.
And remind me again what your client makes?
She makes over $400.
$475,000 a year.
With financial responsibility of supporting two children.
Okay, that's fine.
And a court.
That's fine, and I believe Ms. Talbot has a child also. I don't know where the financial responsibility lies. But that's not the marital lifestyle, 50 grand a year.
Well, the marital lifestyle, if you took what Ms. Talbot said, is that she lived very frugally. That she did not like to vacation, and that she did not engage in those things. And that
Did she live in that nice house?
She did at some
Did
points.
she ever go in the pool, do you think?
She did at some points in the marriage.
Did she own some BMWs that were garaged there?
And she got the BMWs, and she had the ability to provide for those. She also got what she agreed was $250,000.
But this isn't really my question. My question is about the marital lifestyle, and I still don't see anything in the opinion about it.
I understand. My reading of it was different, and I believe the court was taking into consideration how each party conducted themselves within lifestyle and what they each needed to do to continue.
Did she stay in a tiny little room under the stairs?
I would say no.
I would say no also.
But there was some debate in the course of the trial as to how often and how long she did live in that house.
I agree. There was
where
some debate about that.
There was some debate about that. And I think the lower court did give consideration. This wasn't a case where the lower court said no alimony. And we also look at alimony and property division together. The alimony is not in a vacuum. Ms. Talbot agreed.
If you're going to look at the property division, you're going to bump into a serious problem. I mean, I don't know if you know artists. I do. I don't know one who can sell all of their paintings for the asking price, except, well, if they have a piece in MoMA, maybe.
I recognize that, but we don't divide the marital estate based on the cash in the bank. We divide the marital estate based on the value of the assets.
Okay, but what I'm saying is it's all fine and good to say if sold $250,000, but they can't all be sold. There's no even discussion of what the realistic probability of selling 200 plus paintings by an unknown artist is, right? And I don't know what the answer is, but it's not in there even. So I don't, and the judge doesn't quite call it the fair market value.
And that, again, as we're hearing this argument about how Ms. Talbot was not astute enough to advocate for herself, it was her insistence that the words "if sold" be added.
Those were put in because, obviously, because she was saying they aren't worth $250,000. If I could sell them, they would be. She didn't put something against her interest in. She made an attempt, pro se attempt, to put something in to protect herself, and the judge took it the opposite way.
Well, I sort of took it the same way the judge took it.
Well, of course you did.
If you sold
you
them.
You represent the other side.
If they were sold, you would get $250,000, and when we're dividing property.
If you know someone who wants to buy them, you should get in touch with her.
So I took it the same way the judge took it, although I recognize the concept of if sold, there was never any evidence of how efforts she's made to sell them, and quite frankly, her testimony was more in line with the I don't want to sell them than I've been trying and I can't. It was more in line with she had an attachment to these pieces of art than I've been at galleries and I've had representatives.
You don't think the judge has to look at how they can be sold instead of giving the full market price for each of the 200 and then pretending that that's part of the marital estate? Will your client give her $250,000 for them?
I think
Let's discount it. 180? Because no.
I think the other elephant in the room is what was really driving this case is there was a settlement offer on the table, and it was would have been a lot more favorable for Ms. Talbot than what happened.
That's supposed to drive the case?
It is not, but I think that's what drove the appeal. I think that when the trial ended up with a decision that was put Ms. Talbot in a position that she deemed to be far worse than that had she settled, that is when she realized or believed that something had gone terribly awry. The issue from our standpoint is the settlement was an offer from our perspective to save the time, expense, and emotional toll of a trial, and my client was willing to give up more to settle than to spend the time
There
going
is
through
an
the trial.
affidavit somewhere, although maybe it's only on the new trial, that says that her lawyer broke her femur at the signing, but wouldn't leave until they signed the agreement. And she says to get her to leave, so she'd go to the hospital, she signed it, but she was under duress. Now, I know there's been no hearing on that.
And I can't speak to the truthness or lack of truthness of that. Because
You weren't in the room when she broke her femur?
No,
Was somebody? Some lawyer for your client?
no. We were having negotiations via telephone and via Zoom. They were at one location and we were at another. I was not there.
You were on the Zoom, though?
I believe we were on the phone, Your Honor.
Okay.
And thereafter,
I mean, this isn't in the record, so there's no point in going down this avenue. But, I mean, and no, it doesn't seem like anyone moved to enforce the settlement agreement. It doesn't seem like a court found that it either was or wasn't. The court just accepted that I guess, we don't have transcripts, seems to have accepted that she didn't want to do the settlement agreement and treated it as a nullity.
and that's how an agreement would be treated when you show to the court, we no longer agree, it is no longer there. But I do think that in part that is what drove this appeal, is when someone looks back and says, oh, I guess I should have taken that deal, so something must have gone wrong at the trial, and is not considering the other side of the coin, which is your spouse was willing to give you what was a more favorable deal because now there's thousands of dollars on trial, and now we're spending money on an appeal, and at least that was
Okay,
finality and a
all right.
resolution.
Oh, yeah, of course.
So they had prepared a settlement agreement, correct?
Correct.
And do we know what transpired that caused Ms. Talbot to not want to go forward with the settlement agreement? That was an independent decision she made, correct?
The best we understand, she simply reported she changed her mind and did not want to go through with it. Thereafter, we received the motion to withdraw from counsel that there had been a breakdown in the relationship, and that is all we know.
Well, I think I'm not saying we should credit the affidavit, but don't we have this affidavit at the motion for new trial that says she broke her femur and, I wanted her to get in a car and go away, and so I agreed to this, something like that?
Yes,
Am I making that? That's in an affidavit, right?
that is in the affidavit, but a lot of things came out after the trial that would have been known before the trial or during the trial. And after the judgment came out, suddenly there are all of these new statements, including third-party hearsay, that I believe the lower court appropriately ignored when they're trying to get a new trial, saying we have all this new things. Wait a minute, everything you're citing were things you knew before that trial even started.
And no
This-
affidavit from the counsel who broke her leg?
No, Your Honor.
And no affidavit saying she sought one?
No.
I've dominated this, if you want to ask more
So I'm
questions.
over time. If there's no further questions, I would rest on my
All
brief.
right. Thank you very much, both of you, for excellent arguments. The case is submitted. This brings us to the end of our sitting for today. I'd like to thank the court officer and the court staff for their, as always, excellent assistance, and we stand in recess.